We are very excited today as we are joined by Pamela Devata, expert labor and employment partner at Seyfarth Shaw. Hi, Pamela. How are you doing today?
I'm great, thanks. How are you?
I'm good, thank you. We're headed into the new season, so I'm starting to feel nice and refreshed. We're really looking forward to having you here today and looking forward to this presentation that you prepared for us. Now, before we get going too quickly, I want to give everyone the opportunity to get logged in and get comfortable with the GoToWebinar platform. Now is actually a great time to test out that chat and question functionality in the right-hand side of the GoToWebinar platform, where there are two separate tabs. One is for chatting and one's for asking questions. So in either of those, feel free to drop your location. Let us know where you're calling in from today, if you're comfortable. If not, just send us a quick hello. While everyone is going ahead and submitting their answers today, I want to go over a few housekeeping items. First order of business is that this webinar is being recorded and a copy will be sent to you after this presentation has concluded. With that, we encourage you to send this webinar to any of your coworkers or your team, or recap the event for yourself. Really send it to anyone you think who would benefit from this topic. The second order of business is that we want to make sure you get the most out of today's presentation. So feel free to test out that chat and question functionality and ask any questions that might pop up throughout today's discussion. With that, we will have a Q&A session if there's time at the end, where Pamela will try and answer as many questions as she can. If not, we will have her contact information for you to reach out further with her. The last order of business is that this webinar is available for one SHRM and one HRCI credit. So if you're interested in redeeming credit today, make sure to stick around until the very end of today's discussion. That's all my housekeeping items. So I'm going to go ahead and take a look at the chat here and see where everyone is calling in from. All right, looks like we've got Jennifer from Davis, California. We've got Deborah from Washington, Charlon from Whitby, Ontario, Deborah from Idaho. That's awesome. I'm also calling in from Kuna, Idaho today. We've got Donna from Jefferson City. That's awesome. You know, it's really cool to see the geographic diversity we are able to create in this virtual space. Despite geographic diversity, there is one common challenge that many of us are facing, and the reason we are brought together today. And that is that hiring organizations are currently competing for talent in one of the toughest talent markets in decades. As talent acquisition professionals are faced with immense pressure to recruit, retain, attract, and hire quality talent quickly, hiring strategies are constantly being reevaluated, including recruitment techniques and HR technology solutions. But what about background screening processes? Where does background screening fit into your hiring strategy, and how does it impact it? We know that background screening plays a large role in every hiring process, but have organizations unlocked the full potential of having a screening strategy that's compliant and fast for today's talent market? We're not entirely convinced, which is why we're joined by expert labor and employment partner at Seyfarth Shaw, Pamela Devata, where she'll share how hiring organizations can build a screening strategy that's both compliant and fast enough to beat out the competition in today's talent market. Without further ado, take it away, Pamela.
Thanks so much, and I'm so thrilled to be here today, along with Verified First, to talk a little bit about this really compelling issue that everybody's been dealing with. Obviously, 2020 and 2021 have been and created significant challenges throughout the workplace, but certainly in the area of hiring, that's exactly what we've seen happening. So today we're going to talk about how to build a fast and compliant screening strategy. And so without further ado, we're going to go ahead and get to it. I am a lawyer. Please don't hold that against me. But nothing that I say today should be construed as legal advice or counsel. If we do have a relationship with you, an attorney-client relationship, please understand that nothing I'm saying today on this webinar is going to be advice or counsel. It's really for informational purposes only. If you do have questions, we are going to try and answer them as Bree indicated. However, please understand we're not going to be able to give legal advice on those. It's going to be informational only. And to the extent you have a very specific factual question, we likely are not going to be able to answer it. We're really going to be talking today about best practices and how you can mitigate your risk in terms of your screening processes and how you can make sure that it's compliant, fast, and efficient. So what are we really talking about today? You'll see sort of the four areas that we're going to be focusing on. And in the world of background screening, if you will, you often hear a lot about, frankly, the legal challenges and the compliance issues, because frankly, there are so many of them at every different level. We're going to be talking today about how you can ensure a compliance screening process and what things you really should look out for, some things that you really need to consider when you're building your policies and your practices and your specific workflows for your organization. We're also going to talk about some best practice techniques to speed up your screening process. As it was said in the introduction, we are in one of the most challenging labor markets that the country, frankly, has seen in many, many years. And the competition for good labor is felt among every industry, among every geographic location. And as you'll see at the very end of our presentation, there are laws that are making that even more burdensome and even more challenging. New York City just passed a law that we'll talk about in greater detail that basically makes the timing of that hiring process and from recruiting to onboarding substantially, frankly, longer than it ever has been. So if you're in New York City, stay tuned to hear about that and some items that you may be able to utilize to lessen that, but understand there's going to be some limitations. We're also going to talk about the importance of selecting a screening partner, what things to look at, things that you might not necessarily think about when you're going and looking and determining what background checks to run and who to utilize as your screening partner. And then finally, we're going to talk just about a couple of very timely legislative updates in the world of background screening. There are 30 to 40 that we could talk about, but then that would be our entire hour. So we focused on two that are some of the most salient that are impacting employers throughout the country. All right, so let's go ahead and dig in. And again, I encourage everybody to utilize that question function or that chat feature if you do have questions, and we'll try and get them along the way. So how do you ensure a better and compliant screening process? First and foremost, if you get sued, if you have a class action or a single plaintiff lawsuit, right, it is going to be cost of time, cost of resources. It is going to be a distraction. And it doesn't allow HR professionals and security professionals to actually do what you are trained to do, which is find talent, hire the best people, and get people onboarded for your organization. So knowing the lay of the land of the applicable laws and making sure that you are complying with them is going to be crucial. Not only does it cost, again, time and energy to defend a lawsuit, legal fees, but there's an opportunity cost with your resources because you have to step away from what you're doing in order to defend against a lawsuit. So the main laws that are really out there, and most of you should know about these, and if you don't, you should really try and seek advice and counsel either internally or externally so that you have a lay of the land of what your requirements really are. The first one is the Federal Fair Credit Reporting Act. This is kind of the overarching law, if you will, that's going to apply to you as employers anytime that you are going to be utilizing a third-party background screening company, otherwise known as a consumer reporting agency, if you're going to be running background checks. So the Fair Credit Reporting Act is a little bit of a legal misnomer because it does not only apply to credit. It applies to anything that bears on someone's character, general reputation, personal characteristics, or mode of living. So anytime you're going to be running a background check, for example, a criminal background check, an employment verification, education background check, OFAC screening, sex offender, driving records, all of those are going to be encompassed under the Fair Credit Reporting Act. And they have their own specific rules and obligations that you're going to need to be following. The two most complex areas that we see litigation on under the Fair Credit Reporting Act are disclosure and authorization forms. There have been hundreds of cases, class action cases in the last few years against employers alleging that the documents that they are utilizing, so your disclosure, standalone disclosure form that must consist solely of the disclosure, and your written authorization, that they are somehow in violation of the law. This is crucial. It is imperative that you understand those obligations under the law. that you get your forms reviewed on a regular basis. We generally say every 6 months, but certainly every year. The goalposts of this law are changing. This is an old law. It's 40 years old, but the interpretation of what standalone or what solely the disclosure means has been a moving target since about 2015. And every day new cases come down that solidify and clarify best practices in this area. So if you're not keeping up, unfortunately, there's bad case law that says ignorance is no excuse, and you need to make sure that you understand those obligations under the law. The second sort of piece for under the Fair Credit Reporting Act is adverse action requirements. And this bleeds over into my second bullet here, which is ban the box laws. So under the Fair Credit Reporting Act, if you are going to be taking action on an applicant in whole or in part based on a background screening report, then you must follow a two-step adverse action process. Pre-adverse action, a waiting period, and then the adverse action requirement. It's basically like due process. You have to give a copy of the report to the individual, let them know that if there's anything inaccurate or incomplete, that they can dispute that information with the background screening company before you take any hiring decision. So it's a precursor. It's a, hey, we're thinking about taking action about you because of that felony burglary conviction 2 years ago, for example. The ban the box laws are the next sort of evolution of this, and these are state or local laws generally. There is no federal ban the box law for private employers. If you are a public employer or if you have federal contracts, there are other laws and implications. But private employers have a lot of different ban the box laws at the state and jurisdictional level that require a couple things. It used to be that it was a prohibition on an employer asking about criminal history at a certain time in the hiring process. So banning that box, have you been convicted of a misdemeanor or felony? They are now more complex than just that, banning that question. Ban the box laws now talk about when you can mention background screening, when you can provide an individual a disclosure, when you can ask the criminal history question, what you can ask in terms of criminal history question. And the laws are all over the place. The most conservative advice and the most conservative view is that if you want to have a one-size-fits-all and meet all of the laws, is not to ask any of that information or say anything about a background check until conditional offer of employment. You will see, however, that conditional offer of employment is defined differently in certain jurisdictions. Really, New York City and LA, Los Angeles are the two that have what I will call maybe a different version of what commonplace parlance would say a conditional offer of employment is. So understand you have those ban the box laws. The other thing that the ban the box laws do is they change the requirements of the adverse action process potentially. So in certain jurisdictions, you may have to specifically state, for example, the criminal history or criminal conviction on which you are actually potentially basing your adverse action. You may have to give reasoning. You may have to give specific forms or documents to that applicant. You may have to give summary of rights documents. There's a whole variety of items that you might need to comply with under the ban the box clause. And if you don't, then you are ripe for a challenge of litigation. And so when we're talking about how to make your process quicker and better, we're going to talk about some technology solutions. We're going to talk about how your screening partner can assist you with some of these specific requirements in understanding what the law is. If you don't know what the law is, it's going to take a lot longer when you have to deal with some of these things. And then finally is the Driver's Privacy Protection Act. This is the DPPA. This is another federal statute that only applies to driving records. There are items as it relates to you having a permissible purpose in terms of getting this in the first place, right? You're generally not going to want to run MVR, motor vehicle records, or driving records for positions, frankly, that it is not an essential function of the job. And if you are going to be running these, you have to have a permissible purpose to do so, and there's specific consent that you have to deal with as well. The second reason that we're going to want to ensure a compliant screening process is to make sure that you partner with a reputable background screening vendor. We're going to have a whole section on this, so more to come on that, but you do want to make sure that you understand the resources available, who you're partnering with, and who your background screening vendor is when you're trying to make your screening process compliant. The other thing is staying up to date with changes with the law and interpretations. Again, some of these laws are very old. but some of them are being interpreted on a daily or weekly or monthly basis. You have two regulators that enforce the federal law of the Fair Credit Reporting Act. You have the Federal Trade Commission, the FTC. You also have the Consumer Financial Protection Bureau. And both of these organizations have been tremendously busy and active in their enforcement. Some may have rulemaking. There's a split here. Some have rulemaking authority. Some have enforcement, depending on what part of the statute that they are looking at. So you want to make sure that you get legal updates, frankly, anywhere you can. Get them from your background screening partner and vendor. Attend webinars like this. Attend webinars with associations. Attend webinars with other industry groups or with other resources, for example. Law firm mailings and publications are a great way to stay up to date. And frankly, you can go to Seyfarth, which is my firm. You can go to any other firm to get these legal updates. It's really important that you understand when the law is changing, because unfortunately, many of these laws that we're talking about have this component of willfulness. What that means is you can have greater liability if you stick your head in the sand and claim that you don't know about something. And if it's in the media, if it's in the news, if it is, if there have been developments, many courts have said you knew or should have known. And should have known is really the crux there, because in an FCRA class action, for example, there's two types of claims. There's negligent noncompliance on the one hand, which is going to be damages of actual damages and attorney's fees. On the other hand, and that's usually a single plaintiff, one person case. On the other hand, there's a willful noncompliance. Willful noncompliance is a higher level. It means either reckless disregard for the law, right? And or that you knew or should have known and you had some sort of malice there. And so the issue with that willful is that it's usually a class action basis. It can be one person, but they allege it on a class of individuals. And in addition to getting actual damages and attorney's fees, if you do not prevail, there's also punitive damages, which is punishment. So the stakes get a lot higher. Really important to stay up to date with legal developments. Obviously, everybody on this webinar is doing so because you're attending this webinar. But if you're watching this on demand or later, make sure that you are doing that as well. Reviewing your disclosure and authorization forms at least annually. I cannot stress this enough. I do webinars all the time on literally just the topic of disclosure forms. It is one of the hottest areas of litigation on the class action basis. I mean, we are handling 40 to 50 to 60 class action claims a year just on this basis. And there are plaintiffs' counsels out there that do nothing more than go and scour the web or apply to employers only for the reason, not to take the job, but only for the reason of trying to find when disclosure and authorization forms are potentially in violation of the law. Understand that. So it's very important to keep up to date on that specific topic. And then consider having a legal review on a regular basis. And what do I mean by that? I mean, not only your disclosure and authorization practices and policies, but also on your entire background screening program. What do your adverse action letters look like? What do your offer letters look like? What do your disclosure and authorization practices look like? If you have hiring criteria or adjudication matrices, what does your individualized assessment look like? What are you asking your background screening company, for example, to apply in terms of grades? And then what are you doing with those things? Certainly, there's no magic number of how often that needs to be, but that helps with the willfulness argument, right? If you can say, I believe that I went and I got legal counsel on this, is how important this is to me, it does help in that legal argument that you were not, quote unquote, reckless in your disregard for the law. All right, so we're going to get to the next, whoops, I think we are. Yeah, I think we're going to do a poll question now. So Bree, I'm going to turn it over to do a poll question real quickly before we get to our next topic.
Yeah, absolutely. So, we realize, as Pamela was talking about earlier, the importance of that technology piece to give HR and TA professionals the opportunity for value-added initiatives by automating those pieces of their workflow and helping with the compliance factor. So, we recognize this last year has been such a different year compared to all the other years with the COVID-19 pandemic and the repercussions from the pandemic. So we recognize that organizational needs and bandwidth of these professionals has changed. So that's why we want to jump into our first poll question here and garner whether or not figure out here what type of technology your organization is planning to replace or add within the next 6 months. So I'm going to go ahead and launch this poll here. And this is a poll that we are conducting with Verified First is doing with Aptitude Research here, and it's a year-long poll. So your input would be super valuable here. And this is something we will release at the end of the year as well. So we can get back in contact with y'all if you have to provide that then. All right, looks like we've got 40% voted so far. Love to see all those coming in. Again, this is super valuable information for us. All right, 56 here. I'm excited to share these results that we've got going on. We've got some good participation, 65%. Can we hit that 100% today? All right, looks like we're slowing down a little bit, so I'm going to go ahead and I'm going to close the poll, and we're going to go ahead and discuss the results a little bit. All right. So let's go ahead and share these results. So it looks like we have the highest one with no replacements. That's pretty common here. Another one that we're seeing that many organizations are planning to replace within the next 6 months is that background screening component, especially, you know, as they are trying to not only find talent quickly, but make sure that they're finding the talent that is needed for the organization and that's a good organization fit. So while we're doing this process quickly, we want to make sure we're getting some good people in the door here. So with that, I'm going to go ahead and turn it back to you here, Pam.
Thanks so much. Appreciate it. Yeah, it's really interesting to see, you know, we've got a few that are doing assessments, ATS systems, CRM systems. You know, it is, I think everybody has been, technology resources are very important, right? Specifically, things like communications, right? In terms of all of these other pieces. And so, you know, one of the things that we're looking at here is really technology resources and those types of things. I don't think I skipped ahead, Bree. I think this is the next one.
I think we
Perfect.
skipped one slide.
There we go. Let's see here. There we go. Perfect. Okay. Great. Yeah, good. Okay, great. So when we're talking about some of the techniques to speed up our screening, technology obviously is a very big one of these. So what do you want to look at when you're thinking about making these things faster? Number one, what checks do you care about? What positions are you hiring for? And what checks do you need? Inevitably, certain types of checks, whether you're doing them yourself or whether you're utilizing a background screening partner to do them, take longer than others. So employment verifications almost always take longer. Education verification sometimes do, sometimes don't. It depends on what level of education you're looking at and where that information is stored. Criminal history can generally take, it's usually the fastest. Sex offender registry checks are usually very fast. And driving record checks are usually very fast. But it really depends on what you care about. So for example, there's a lot of legislation about credit checks, right? Restrictions on the use of credit checks. Now I'm talking about pure credit checks at this time. So there's 10 different regulations in terms of 10 states and 2 local jurisdictions, New York City and Chicago being the local, and then the other states that have restrictions on when you can run a credit check. Credit checks are generally quick, but the issue is, why are you utilizing them? I was lucky enough to speak before the EEOC a few years ago now on the use of credit checks in employment and the issue of why employers are utilizing this information. So you really want to understand what information you need, what is going to be relevant, what's going to be job related and consistent with business necessity to get you the information that you can have to determine the best fit for that job. So for example, if you are in a safety sensitive position, if you're hiring for that, or if you have a vulnerable population, or if you're regulated, if you're a financial services institution, or if you're a healthcare institution, and you have to run certain checks, obviously you need to comply with the legal obligations and you need to comply with industry standard, for example. to make sure that you're not going to put yourself up to unnecessary negligent hiring or negligent retention claims. But you need to really be thoughtful about that. Not every position needs the same background check. I would caution you that you want to make sure that for every applicant in every position, you are running the same check. So for example, if you're hiring for a finance manager, every single person who's a finance manager should have the same check that is conducted, right? However, a finance manager may have very different checks than somebody who's on a manufacturing line as an entry-level position. So you're going to need to make sure that you work with your counsel inside or outside to understand what is available in terms of types of checks. And when you're looking at these things, making sure that you're not getting things that you don't need, because that can actually slow down the process. We just talked about technology. What are you using in terms of technology? Well, you've got applicant tracking systems. Applicant tracking systems can be wonderful tools. And there's been a huge increase in the different types and customization available with applicant tracking systems, right? Now in the day of technology, online applications, computers, remote working, et cetera, we're seeing a really big increase in mobile accessibility and applying, while you're on the go, for example, instead of bringing in paper applications. I mean, there are many companies who have gone purely electronic in terms of their hiring systems. Applicant tracking systems are wonderful as it relates to that. How does that tie into screening? It ties into screening because many applicant tracking systems are integrated with your background screening partner. And so sometimes you can have a really wonderful and valuable user experience if you connect your applicant tracking system with your background screening company. And there's a myriad of ways of doing this. Sometimes it's a launch of a candidate entry system, which I'm going to talk about next. Sometimes it's an integration where an applicant will put in their information, their first name, their last name, their address information, for example. That information will then go over and they will not have to put it in again, right? Because it will already go over to the background screening company. And then there may be one or two items that they need to collect, like date of birth, for example, or social security number. But that's going to be in that second pass, possibly. I could talk for a long time about applicant tracking systems. The other type is this candidate entry flow, and that can launch from an applicant tracking system, but it can also launch from your background screening provider's website. So a candidate entry workflow is generally when the candidate or the applicant is provided with a workflow of information where they are inputting certain PII, personal identifiable information. So they're including their first name, their last name, their middle name, their address, their date of birth, their social security number, their driver's license, for example, all of the crucial tools that are needed for a background screening provider to actually effectively run a background screen. So you want to make sure that you understand that sort of flow. The other thing that the candidate entry workflow usually does is that's where it can house those documents that are required before a background check can be run. So you heard me talk about before, disclosure and authorization forms, right? That is, in that workflow, you can have a standalone disclosure, you can have an investigative consumer report disclosure, you can have your California specific consumer disclosure that's required and must be separate. Then you can have your authorization and then any other state or local law items that you might need. And all of those things can be housed in that candidate entry workflow, for example. You want to make sure that you understand what that candidate entry workflow looks like because it is going to be crucial. That is going to be your compliance obligation as an employer under the law. But as it relates to making a more efficient, more effective, faster screening process, now the burden is on the applicant, right? If it's sent immediately, you make the offer, the email gets sent, they can do it in a matter of minutes and they're not waiting, right? They're not waiting to go and fill some paper form out and scan it back in. They can do it on their phone or their iPad or their tablet or their computer or whatever device they have. And it can make it really quick and efficient. So those types of integrations, applicant, candidate workflows are going to be really helpful. Other technology to speed up your screening process, adverse action assistance. So I told you once you have decided that you're going to get the background check back, and you're going to be looking, for example, you're going to need to do an individualized assessment. You're going to need to review that, which is going to be the next thing. But there, some technology solutions, both in ATS systems, frankly, and in candidate workflow situations, in your background screening company, often have adverse action solutions that can assist you. There's many different kinds of these. Some of them actually will show you a letter that you can modify and you can tweak it and send out. Some companies will actually send out these letters on your behalf, either electronically or via regular mail. Some companies will launch instructions that you go through your own workflow, for example. And there's a myriad of different types and many different levels of those. But that's a technology solution that it's important that you understand that is out there that you may decide to utilize and you may not, right? There are many companies that do this on their own, given the different laws at issue. But that's a technology solution that you want to understand whether or not your background screening provider has, and or your ATS system has as well. Another technique to speed up your screening is what I call adjudication or hiring criteria. It used to be that these sort of adjudication grids or matrices or hiring criteria were really frowned on. And they were frowned upon because the argument was it was a green or red, and nobody was looking at the background report, and nobody was taking into consideration those required individualized assessment factors that the EEOC and that the ban the box laws either require or strongly encourage you to take into account. I am a true believer in adjudication criteria and hiring matrices, and here's the reason why. So back in 2012, when the EEOC came out with their criminal history guidance, they built in and said, and again, this is a federal agency that is, their entire focus is to prevent discrimination in the workplace, right? So to prevent discrimination, both disparate treatment as well as disparate impact. And disparate impact is basically you have a neutral policy, but it impacts certain groups in a negative or adverse manner. And so when you're dealing with adjudication and hiring criteria and looking at evaluating background checks, what the EEOC said was, listen, you have to take into account a couple of things. You have to take into account these green factors. This is a case called Green versus Missouri Pacific Railroad that came out way back in the 8th Circuit Court of Appeals a number of years ago. But they said, look, in order to determine whether or not, specifically when you're utilizing criminal history, whether or not something is job related and consistent with business necessity, such that even if it has a negative impact on certain minority groups, so again, men, Hispanic individuals, African American individuals, even if a policy would potentially have this disparate impact, you defend against this disparate impact by saying, no, it's job related and consistent with business necessity. The way you do that is to look at things like looking at specific factors like what is the specific job in question? What are the duties of the job? How old was the specific offense? Is there a correlation or a combination, right, of that specific job to that conviction, to the ability to perform the job? And then the EEOC came out with these individualized assessment factors like the age of the person at the time of the offense. Has the person worked prior or after? Is there any rehabilitation efforts, for example? What type of crime was it? Was it a crime to property? Was it a crime to a person? What type of the offense and the veracity of the offense? So, for example, are we looking at something that was a minor misdemeanor? Are we looking at something that was a serious felony that had, for example, that was related to violence or theft or fraud that absolutely has a correlation to the ability to somebody being able to perform the job? Have there been any rehabilitation efforts? Do you have character references? All of those types of things. So that individualized assessment takes a lot of time and energy and work. And so the issue is going to be, if you have an adjudication criteria or matrix, you can literally build all of those things into that matrix. The really reason that I love these is because there may be minor crimes or minor things that have nothing to do with the job whatsoever. If you are having a position, give you an example, that does not require driving whatsoever at all, and the person has speeding tickets, or they have a misdemeanor DUI, for example, and they're never going to be driving for you at all, and the crime was old and minor and not related to the job, you don't even need to look at that report. You can pass the person. And so I really like adjudication and hiring matrices because they can actually save you time and energy with a technology solution, not to nix the person and to ding them, but to include the person in. You need to make sure that you understand the legal ramifications. Having a do not hire or a red or a fails is going to be very risky with just having that on an adjudication matrix. It's going to be, frankly, illegal in some jurisdictions like New York City and others. But if you have a pass or you have a review or a heightened review, so for example, there may be certain things where you may have a first level reviewer that they look at all of the misdemeanor crimes and they decide whether it's enough that somebody needs to look at and take and do the individualized assessment. But you know what? They're going to be able to make that determination. But they may also have a heightened review that might involve, for example, a higher level manager or supervisor or legal or security or risk or some other part of the group of your organization. And those may be looked at with a committee or may looked at a little bit differently because of the veracity of the type of conviction that there may be. Adjudication criteria and matrices can be really wonderful things. They can actually be very, very useful in defending against claims of discrimination. It can also be a manner that really will streamline your hiring process. If you don't have to look at every minor, tiny little piece, and that's going to be sometimes helpful. And these are grids and matrices, for example, that you can work with your background screening company potentially to apply these pass grades to as well. The last thing in terms of techniques for speeding up your screening is criminal history questions. And people get really nervous when you mention criminal history because of all the ban the box laws. And we had, starting into sort of 2012 and then really ebbing forward, we had lots of companies who would say, I don't even want to ask about criminal history because I'm just going to ask it wrong. And I just don't want to deal with all of the laws and the regulations and the EEOC guidance that came out. And I have to tell you, I think that that the pendulum has swung a little bit now. It used to be that everybody would ask it and they'd ask it on the application and it was a knockout, right? It had a chilling effect. This is why the ban the box laws actually came into being, because it did have a disparate impact on individuals, and all of these laws were then passed to get rid of it. I believe that it's really sort of swung back into the middle now, and the reason being is because a criminal history question at the correct time, generally after conditional offer of employment, is going to be able to be utilized to do a couple things. One, it shows somebody's judgment if they're going to be truthful. If you ask a legally compliant question at the right time, you have the ability to show that individual's judgment if they are forthcoming and if they are truthful, or if they're going to be falsifying. The second thing that a criminal history question does, again, if you ask a question, and you can do this in your applicant tracking system, you can do this as a second pass, for example, after conditional offer. You can do this as with your candidate entry flow with your background screening company, is that it allows you to build in a dialogue with the candidate to get all of that other information that you frankly need to do the individualized assessment. So instead of saying, have you been convicted, click yes or no, you say, have you been convicted of, and perhaps you narrowly tailor that, a crime in the last 7 years consisting of theft, fraud, or violence, because maybe that's all you care about. Now, you might not. You might care about a longer period of time. You might care about every conviction, and you might want to do a specific individualized assessment on each one. But you can tailor that to the position. You can tailor that to what you actually care about, and it streamlines that. The other thing that it does is, let's say you have an appropriate question, if yes, please put the facts and circumstances surrounding the offense, how old you were at the time of the offense, mitigation efforts, for example, where you worked before and after. So instead of having to go back and wait and ask the person, you have streamlined that by asking that question on the front end as well. So really good idea to think about. You got to ask the right question. You got to understand when to launch that. And there you go. We talked a little bit about the technology solutions. The next topic we're going to talk about before we go to our legislative updates is the importance of selecting a screening partner. And you'll notice we use the word screening partner here. Background screening companies, sometimes people use the word vendor. I don't think that that's a derogatory term, but some people do, right? You really do want to pick a company, though, that is going to be your partner, right? And understand what services are they offering? How do they differentiate themselves with others? And if there's a service that you really believe you need, can you get it from that screening partner? What is their customer service philosophy? Is there a function? Is there a dedicated resource or a person that you can call, or a group of people, right, that know who you are, that know your hiring criteria and matrix, that know what you want to get? For example, if you don't care about dismissed records and you don't ever want to see them, perhaps you ask your background screening company not to provide that. If you don't care about misdemeanors and you only care about felonies, you can do that as well. There's lots of other things that you can look at when you're working with a screening partner. What are their value adds and extras? Every background screening company is very different in their philosophy on value adds and extras. That could be, for example, education. That could be providing sample documents. Again, you still have to get your own documents reviewed. You need to make sure that you are compliant and cannot rely on anybody because it's your obligation under the law. But do they give you a starting point, right? What technology solutions do they have? We talked a little bit about that. But really, what are their other value adds and extras in terms of that? Do they give you access to resources? Do they give you access to education? Turnaround time. Goodness gracious, turnaround time is a big issue because we're talking about how to make your screening more compliant, but also more streamlined and more efficient and quick. Sometimes certain jurisdictions take a lot longer than others to get information. The reason is because, unfortunately, and you may or may not have heard this, but there are a number of jurisdictions that are really restricting the ability for anybody to get information. Michigan and California are the two biggest right now. Every single company in the screening world is struggling with how they're going to get criminal history information in those jurisdictions, because what's happening is the courts are restricting access to getting information other than by a name. So dates of birth are being pulled out of that information. Well, just like you have all of these legal obligations under the law to follow the Fair Credit Reporting Act and the Ban the Box laws, et cetera, background screening companies have similar, yet different, but similar obligations under those laws. So they have obligations under the Fair Credit Reporting Act to take reasonable procedures to ensure maximum possible accuracy. They're just not going to throw something in a report, right? So they need to utilize personal identifiers, and if they can't get those, it becomes very challenging. So having a clear communication of expectations with your screening partner that, certain jurisdictions, then, New York AOC is going to take longer. Cook County, Illinois is going to take longer. And knowing that expectation and what that communication is with your screening partner when something might be taking a longer period of time, so that you can be aware of that and build that in. Certainly, we're going to talk about New York City in a few minutes, but there are certain legal restrictions on some of those items as well. Obviously, cost is always a factor. It certainly is not the only factor, but it is always a factor when you're dealing with, your providers and partners. One thing to consider is, if you are a company that has, a parent company and you might have subsidiaries, volume is usually helpful, right? Making sure that you understand that sort of information as well is going to be helpful. And then last but not least, what technology resources are offered? How hard is it for you to go and look at a consumer report on your phone? Is it secure, for example, when you're going to look at that information? How easy is it to use the technology? Is there an integration with your applicant tracking system? Is there a candidate workflow? Do they have technology resources? All of the things that we talked about on the slide before, if you remember, to assist with adjudication or with your adverse action process. All of those things are going to be really important for you to consider. All right, we're going to go ahead to the next poll question. I'm going to turn it over to Liz.
All right, Pamela. Well, thank you so much for sharing all that information. And I love the fact that you brought up the importance of selecting a screening partner. Here at Verified First, we recognize the difference in just being a provider versus a partner. Partners think about their users throughout the entire life cycle, whether that be recruiting, onboarding, implementing, integrating, having built-in compliance tools, or certain client care. So that piece is super important here, which leads me into our second poll question that we have here. And again, we would love for the audience to participate and answer this question here. And we want to know, is your background screening currently integrated with your hiring platform? Whether that be your ATS, your HRIS, your payroll platform, whatever it may be, we would love to see if you all have reached that integration stage. And this isn't part of the question, but while you're answering, I'd be curious to also see of those who have integrated, if you so wish to, feel free to drop in the chat how those integrations are working too. We talk a lot about this integration feature. However, there's so many things to consider, like the return on investment with that integration. Something Pamela also talked about a little earlier was that ATS and background screening component of being able to have that integrated version where you can scrape the data over, which reduces the data entry and streamlines the hiring process, and making sure that that integration actually crosses over to the platforms you currently use. So there's a lot of important stuff here. I'd love to go ahead and share the poll results. We've got about 58% voted, 59%. Can we reach that 100? I know we got to 68% last time, so I'll give it a couple more seconds here, see what everyone else has to say about their current integration with their platforms. All right, we're reaching 67, doing good. Awesome, we reached that 68%. So I'm gonna go ahead and I'm gonna close the poll here, and we're gonna go ahead and discuss these results. All right, so as you can see here, it's almost a 50-50 split with how many people who have integrated with their hiring platform and how many who haven't. So this isn't actually that shocking here. However, that integration piece is really key to that streamlining the hiring process, reducing data entry or duplicate data entry there. So this is very helpful information here, and we'll go ahead and keep that in mind throughout the rest of today's presentation. All right, Pamela, you can go ahead and take it back on over.
Thanks so much. Yeah, really interesting with this poll. And look, it doesn't, you don't have to have an integration to have a streamlined process, but certainly if you do have an ATS, you want to think about how that works. One way you can do it, is having, understanding the touch points that your recruiters are making. The more often they have to go into two different systems, right, the more time that it generally takes. So there's not a one size fits all, but certainly really interesting in terms of that response there. All right. So the last thing that we're going to talk about quickly before we get over into some questions. So if you do have any questions right now, please go ahead and start thinking about them. But we did want to give a quick update on two brand new areas of the law, New York City and Illinois, that have recently passed. They passed this year. One just went into effect just a month ago, that have really are causing some significant potential pitfalls and also a source of potential delay in the hiring, right? And so obviously this webinar is really talking about trying to get a compliant and fast screening strategy. And so anything that's going to run into that, we wanted to make sure that you understood. So New York Fair Chance Act, this is not a new law. This is an old law, but it was just amended. So it was amended, and the amendments go into effect July 29th. The New York Human Rights Commission has authority over the New York Human Rights Act, which is the New York Fair Chance Act is part of. And basically, there's been guidance issued by the commission now as well, but the specific amendments and the guidance really changes some things and makes clear, frankly, what the New York City Commission has been sort of enforcing for a little while, but it was never written. Now it's written. So basically, what does it mean? It means that for employers in New York City, hiring in New York City, you cannot mention the word criminal history, background check, anything related to that whatsoever prior to a conditional offer. That means no job postings, no applications, no putting it on your website, no putting it anywhere, no interview, nothing at all whatsoever. If someone brings it up, you have to say, we do not consider that until after conditional offer of employment. That's actually not a sea change. That's been around for many, many years. But the issue is what conditional offer means. So it's been redefined, or at least reinterpreted by the New York Human Rights Commission to mean only criminal. What that means is the offer can only be conditioned on criminal history. MBR history as well, because that has criminal history in it, or an ADA medical test or something that otherwise cannot reasonably be known. What does that mean? It basically means that if you are going to be hiring someone in New York City and you want to run employment verifications, education verifications, drug tests, OFAC, sex offender registry, anything that is not criminal, sex offender registry is going to be a questionable one, so get some advice on that. But anything that is not purely criminal, you cannot do it until, you cannot wait till the offer. You have to do it before the offer of employment. So if you're going to be utilizing a background screening provider to do this, arguably you may have to do a bifurcated check. One disclosure form, one authorization, get the check, review it, consider adverse action, go through that process, then give a conditional offer, new disclosure form, new authorization, new consent forms, criminal history question, and then you get the criminal history. You can see how this takes a streamlined approach and potentially broadens it astronomically. You also can't use pending records or review pending records. So if you are in New York City, please, please, please get advice and counsel on this. It's a big issue. There are huge damages, and this is potentially a sea change. A lot of employers are choosing not to run certain checks in New York City, or to take them in-house, or to make sure that they're working with their background screening provider to understand that they have that streamlined impact and they know what they're doing. The other area of the law that has changed recently is Illinois. This goes back to March. Illinois, really the change is into how you are evaluating certain information and components on the background check, specifically criminal history. So this is a change to sort of the ban the box law in the Illinois Human Rights Act. Again, this is similar to the Fair Chance Act, but in Illinois, it is the Illinois Human Rights Act that prevents discrimination on certain individuals. And basically what the Illinois Human Rights Act change and amendment does here is now it requires that any sort of criminal history that is going to be reviewed have a substantial relationship to the job in question or create an unreasonable risk to property or safety of others. You must look at a variety of specific factors. They're very, very similar to the EEOC factors and the EEOC guidance on that, so you understand that. And you must also now have information in your pre-adverse action statement that states the specific disqualifying conviction and the reason that it is substantially job-related or creates an unreasonable risk to property of others. So you must specifically put that reasoning in that pre-adverse action letter. You also may have to give an explanation that the applicant can provide you additional information about mitigation or rehabilitation. You now must wait a minimum of 5 business days between those letters. It used to be a reasonable period of time under the federal law. There is a specific 5-day waiting period, business day waiting period now. And then again, if you are still going to take adverse action, you have to tell the person again the conviction, again the reasoning. If there is an appeal or reconsideration process, there doesn't have to be, but if there is one, you have to explain it to the person. And you have to specifically tell the individual that they have a right to file a charge of discrimination under the IDHR, the Illinois Human Rights, the Illinois Department of Human Rights. So what that means is you've got LA on one coast, you've got New York City on the other coast, and you've got Illinois right in the middle that have very, very specific and detailed, challenging requirements when you're considering taking adverse action on individuals. So with that, we've got a few minutes left, and I'm going to go ahead and pass it to Bree to open it up for questions, and we'll try and answer some of the questions that have come through.
Yeah, thank you, Pamela. I mean, this has been an amazing presentation done by you today. I feel like I have learned so much information, and for any of our audience members who are looking to gain more insight from Pamela, feel free to ask any questions in the chat here. While we're waiting for those to come through, I just want to give a big thank you to Pamela at Seyfarth Shaw for this amazing presentation. It is so helpful to be able to have you and help provide this resource to our HR and TA professionals. All right. So it looks like I've got a question from Tara here. Just give me a moment to go ahead and dissect this really quick. All right. This one is a little bit longer, so just trying to get through to the meat and potatoes here. All right. So it looks like they are a organization startup, and they are looking to implement background screening for their corporate team here, and they have not run background checks on any employees thus far, but we're curious about the compliance aspects surrounding the timeline for that. They would like to know if they can run background checks on current corporate people or only on new hires. If they can run it on current employees, they're pretty sure they wouldn't be able to make any employment decision based on their results, but they're just curious to see on what you might have to say about that, Pamela.
Sure. So you can run a background check on someone at any time, frankly, during their employment, as long as you follow the relevant laws. So, for example, the Fair Credit Reporting Act, any of the ban the box laws, et cetera. The ban the box laws are generally not going to apply unless you're taking adverse action on that individual. Of course, the longer the person has been working there, right, the fact that they had a conviction 5 years ago and then have been working there for a year is likely going to be less job related, right, because they've been performing that job generally successfully. But as long as you follow the law, there's no limitation on the fact that on the timing of running that background check. As long as you have that disclosure, that standalone disclosure, as well as any state law and required documents and that authorization, then you can go ahead and do that as well. The Fair Credit Reporting Act is absolutely going to apply, though. So you need to make sure that you're complying with that law, even if you are running out on that. And one just quick note, guys, my email has a little typo in it, and I'm not sure why, but it does. But Seyfarth is spelled wrong. So it's Seyfarth, and hopefully we'll be able to get that changed when we send out the slides. So sorry about that. But if you want to get a hold of me and you use the email on the screen, you're not going to be able to. So it's Seyfarth, Seyfarth.
Awesome. Thank you, Pamela. And it looks like we are actually approaching our end of time here. So I'm going to go ahead and close the questions that we have. However, if anyone else has any questions that we haven't been able to answer today, we have provided that contact information and we will correct that on the slide here. That way you can reach out to Pamela for further questions here. Now, I do want to go ahead and discuss a little bit more about our SHRM and HRCI credit opportunity for today's discussion. For anyone in attendance, for our live attendees, if you are looking to redeem that SHRM and HRCI credit, stick around just a little bit longer for that post-webinar survey, and information on how to redeem that credit will be located in the survey. For any on-demand listeners listening on a different day, you can check your email and information on how to redeem credit will be there. It is amazing that we're able to provide this resource to our HR and TA professionals as we truly evaluate that education piece here. If you're ever looking for any more SHRM or HRCI credit, we do have another webinar series called HR at the Table, where we speak and interview with some of the most notable in HR and TA professionals at America's, about their role at the executive table. You know, we talk about these hot topics and dissect these HR hot topics. So if you're interested, visit verifiedfirst.com and go ahead and sign up for our next webinar, which is actually with another member at Seyfarth Shaw, Sam Schwartz Fenwick, and he will be discussing how HR tech improves diversity in hiring. It is going to be a great conversation, so we really hope you get registered for that. Again, you can visit verifiedfirst.com. Now, I'd like to explain a little bit more about what Verified First is and does. We did sponsor today's webinar today. Verified First is known for delivering a streamlined screening experience. With revolutionary technology and a slick patented browser integration, Verified First instantly connects with over 100 HR tech platforms, providing clients a turnkey experience with top-notch client care. So if any of you are interested in revamping your background screening process or discussing anything that we've talked about in today's webinar, feel free to reach out to that contact information and we will have one of our experts reach out to you. All right, on that note, it has been an amazing discussion with you today, Pamela. Thank you so much for providing your expertise and your input, as I know that not only have I learned a lot, but our attendees have also learned a lot. So with that, take that post-webinar survey, let us know how we did, get your SHRM and HRCI credit, and I hope you all have an amazing rest of your day. Thanks, Pamela.
Thanks, everyone.